Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I am a partner at the firm of St. Fruit American LLP and I'm based in BC. We've got offices in British Columbia, Alberta and Ontario, and we represent clients throughout Canada other than Quebec and the territories. You're welcome to send us questions through the social media platforms on disability issues and I'll respond to them as best as I'm able. We've got about 30 minutes, so I'll dive right in. One thing that came up this morning is a question that relates to anxiety. And it's an interesting question. It says, what types of anxiety conditions would qualify for LTD or for disability? If you've seen these shows before, or you've watched our TV shows, you would know that when we look at a disability claim, the most important thing is functional impairment. I've said this so many times. The condition itself is important, yes. The diagnosis is an important feature. But the most important thing when an insurance company assesses a disability claim is what is the functional impairment. In other words, what are the restrictions and limitations that would prevent a person from performing the essential duties of their occupation? So if there is a diagnosis for anxiety, generalized anxiety disorder, and the doctor completes the forms and simply says, my patient has generalized anxiety, they cannot work. That claim is going to be denied. The reason why? Because there is no details with respect to what the restrictions and limitations would be. Look at it from the perspective of the insurer. You get forms completed by a insured, the claimant, as well as the doctor. The doctor says, my patient has anxiety. The person says, I have anxiety, I cannot work. But there's no further details given. When you have an anxiety disorder, many people with anxiety are able to work because they're being treated, they may have been doing counseling, they may be taking medications, it may be at a lower level of anxiety, but they're able to complete their functional duties, the essential duties of their occupations. So when a claim is submitted, and this goes to any claim that is submitted, but regardless of the condition itself, you and your doctor have to outline what prevents you from performing your duties. How does your condition, being anxiety, impact your ability to perform those essential duties? And I've just said this many times before, if it's a mental health disorder and it's anxiety, maybe it is that you have a lack of focus, concentration, poor memory, cannot multitask, cannot comprehend new information, cannot work with the public, you may have social withdrawal, you may have panic attacks, you may be unable to multitask, you may be unable to leave the house, you may have physical manifestations of your anxiety condition in terms of heart palpitations, dizziness, etc. Detail those and then compare it to what it is that you are required to do in your occupation. In other words, what are the essential duties of your occupation? I've said this before as well as an example. If you were to work as a bank teller in a bank, you're working with other people's money, you're working with the public, you may have to deal with a difficult client, you may have to multitask, you must focus and concentrate, as with every job. But when you're dealing with big sums of money and you have to advise people as to what the options are if they've got questions, you have to be on the ball. And you have anxiety and it's impacting your ability to think, your cognitive function is impaired, that would explain why you would be unable to perform the duties of your occupation. So it's not what types of anxiety would be approved, it is the level of severity and the functional impairment and the extent of the functional impairment. That is the key question when we look at why should a claim be approved under a disability policy. Remember, the policies are contracts. So there's a contract in place. You, as the person making the claim, have a duty, and that is to prove that you fall within the definition of total disability. That phrase may be misleading, total disability. In everyday language, one would think total disability would mean somebody who is bedridden, who cannot feed themselves, who cannot dress themselves, even comatose. That's not the case when you look at a disability policy. Their total disability would simply mean that you cannot perform the essential duties of your own occupation. And if there is a change of definition in your policy after a certain period of time, you would have to prove that you cannot perform the essential duties of another occupation for which you have the transferable skills. So when we look at these cases, remember, it is on, well, I'll just say this, it is based on the medical information that is submitted and the information that is submitted by the person making the claim to confirm and to prove that you are unable to perform those duties. During the assessment period, the insurance company will appoint a case manager, and the case manager will likely call you to have what is referred to as a functional telephone interview to ask you questions. And those questions would be related to your function and your treatment. Who are you seeing? What medications are you taking? Are you doing counseling? What type of counseling? How often? Is your condition related to work? What are the symptoms? What are the restrictions? What are the limitations? Are you able to do things around the house? Do you have children? Who drives the children to school? Who prepares their meals? Do you watch TV? Do you read books, etc.? All those questions relate to function. And again, when we look at a disability claim, if you have the diagnosis, they will be exploring further how that diagnosis and its related functional impairment is impacting your ability to work. So it's extremely important that when you submit your claim, that you come at from that mindset. How does this impact my ability to work? If your claim were to be denied, as we've said throughout these sessions, you're welcome to contact us. We offer free consultations where we would review the policy, the denial letter, medical records if available, and discuss with you your personal circumstances to explore whether you have options, which you likely will have, and you can make an informed decision as to which option makes most sense to you. Okay, so let's go to some questions that have come in. First question is on Facebook from Marilyn. My insurer has denied me several times now for LTD. I've tried appealing the decision, but with no success. Why do I keep getting denied, and what can I do differently? That's a very general question, but it's a very important question. The reason why it is important is there's another issue that relates to this question, and that comes down to there's a difference between an appeal and a legal claim. The insurer has denied your claim. When they denied your claim, that triggered the running of something referred to as the limitation period, which is the timeline within which you can pursue a legal claim. That timeline is different from the appeal timeline. So if you get a letter from the insurance company denying your LTD claim, the letter may say you have the right to appeal, and you must do so within a certain period of time, be it 30 days, 60 days, or 90 days from the date of this letter. Further down, there may be, and should be, reference to something called a limitation period, where it may say that no legal claim may be filed outside a certain period of time. Those two things are different. The limitation period is a statutory defined period within which you must file a legal claim. And if you miss that period, you will not have a claim to pursue. Very important to understand, the limitation period runs regardless of whether you are pursuing an appeal. So for most provinces, the limitation period is 2 years. You would have to refer to your own insurance act of your province to establish what that insurance provides for the limitation period. And again, you can contact us if your claim is denied so we can review the denial letter and advise you of what the limitation period is. It's very important to understand this because if you are engaging in the appeal process, the limitation period continues to run. And you have to ensure that you do not miss the limitation period if you continue to engage in the appeal process, because if it runs out and you're still in the appeal process, if that appeal is denied, you will not have a claim to pursue. Now, why does the insurance company in this case continue to deny the appeals? I don't know the factual circumstances, but I can say this. When you have a claim with an insurance company and that claim is denied, and you submit an appeal, you are submitting the appeal to the same entity that denied your claim. Are all appeals unsuccessful? No, they're not. But when you engage in that process, you are providing further information, or should be providing further information as requested by the insurance company from their perspective. You may be providing information that, without your knowledge, may not be helpful to your claim. Or you may be dragging out the decision-making process where you could have pursued a legal claim. A legal claim is different. When a legal claim is pursued, you are handing over your claim to a representative, meaning your lawyer, and your lawyer will be dealing with the insurance company. No communications will come to you through the insurance company any longer. You don't need to deal with the case managers. It is all in the hands of your lawyer. Your focus will be to handle or to focus on your treatment, to make sure that you see your doctors regularly, and that you are following through with appropriate treatment with a focus on getting better, all along while the lawyer is dealing with your claim. As I've said before, when we are contacted by prospective leads and they have a claim that has been denied, we discuss with people what their options are. And it may be that your best option is an appeal if that is what you decide to do, but often it isn't. Where a legal claim may be the best option to pursue. At least by the end of the consultation, you will have been in a position now where you've been placed in a position where you can make an informed decision as to what option makes sense to you. If the appeal is denied, you still have the right to follow through with a legal claim, absent or conditional rather on some circumstances, because some unionized, not all, some unionized employees cannot pursue legal claims. Okay, Marilyn, if your claim continues to be denied, please reach out to us. As I said, we can offer you a free consultation and you can make an informed decision as to how to proceed further. Then there's a question on YouTube from Even Stephen. I've been on leave for anxiety and agoraphobia for the last year and a half. Under my doctor's orders, I've started trying to go to a local gym to get out of my home and get some activity. My insurer said that since I'm able to do this, I can return to work and it's cut me off. I'm not clear to return. My doctor never made that recommendation. What can I do? This is extremely aggravating because this continues to happen. When a person has a condition and they follow through with treatment recommendations, because this specifically is a treatment recommendation. You have anxiety, you have agoraphobia, the doctor is recommending that you do exposure therapy by leaving the house, by going to the gym, by trying to do these things. When you follow through with the treatment advice, which is what you are required to do under the policy, the insurer in this case is using that to deny your claim, to take the position that you are now able to complete the duties of your occupation. These two things are entirely different. Being able to now leave the house or try to leave the house, try to go to the gym, does not equate to the ability to return to work and perform your essential duties of your occupation. Clearly, from what I'm reading here, the doctor has not cleared even Stephen from going back to work, and he is simply still in the process of treatment. Is there improvement? Seems to be the case. What would happen if even Stephen is forced to return to work early? Very likely a relapse, eroding all gains that have been made through treatment, which may result in a prolonged absence from work. So what can you do? Please reach out to us so we can discuss with you what your options would be. We would like to review the denial letter and discuss with you the extent of the recovery and the doctor's advice. Usually what would happen in a case like this, if you were to go through with trying to convince the insurer that their decision is wrong, you would want to get your doctor to put in writing why it is that the decision that they have made is not correct, why you continue to be unable to perform your duties. Consider what I said earlier. If even Stephen were to be a bank teller, this is an anxiety situation with agoraphobia as well. Simply being able to leave the house or trying to do so and going to the gym, which is part of treatment, does that now mean that he can focus and concentrate, multitask, deal with difficult clients, show up at work every day, even when there is an increase in anxiety? Very likely not. So in those instances, again, it is extremely important to see the doctor on a very regular basis to make sure that the doctor records your ongoing restrictions and limitations, your reports of symptoms. If there's improvement, put it in context. What does that mean? I'm able to leave the house now once a week, where before I couldn't do it. I forced myself to go to the gym, but I could only stay for 20 minutes and then had to leave because my anxiety came back, but I'll try again next week. That's what is done in these cases. Usually everything is very gradual. And if that is the case, that surely does not lead to a conclusion that the person no longer is unable to work. So make sure you see your doctor regularly. Make sure that things are put in context. If there is details of improvement, what does that mean again? And ultimately, if your claim is denied, like it is in this case, do contact us and we can discuss with you what your options would be. Okay. Bramblepath says, I recently went back on LTD. My doctor said that it's unlikely I will be able to return before retirement. My insurer has started asking a lot more questions now, and I think they are going to deny me. Are they being difficult because I'm unlikely to return? What should I do if they deny me? Bramblepath, so if what I'm reading here is that you were on LTD before, you returned to work, and you're back again, which may be that happened during the recurrence provision of your policy, which means that your condition worsened. Your doctor says that you will not be able to return to work before retirement. It really depends on what your age is now. For example, if you were to be 40 years of age, retirement may be 65, or benefits may be payable to the age of 65 under your policy. It's a difficult opinion to justify at this juncture, depending on the condition itself. The focus has to be now, what are the restrictions, limitations as you are sitting in front of the doctor now. Make sure that you follow the recommended treatment. Make sure you see your doctor regularly. And make sure, as I said before, that you continue to report to the doctor your ongoing restrictions and limitations. If your doctor is recommending that you engage in other forms of treatment, do that. If things are not getting better, maybe ask the doctor what other options are available to me. Should I be referred to a specialist? Make sure that at your end, you're doing everything that is required of you under the terms of the policy, so that the insurer cannot turn around and say, well, you've been on this medication now for a year, there hasn't been a change, why is something else not being explored? Or if the medication isn't helping, or the counseling isn't helping, if it's a mental health condition, why have you not been referred to a psychiatrist? All of those things need to be explored. So be proactive in exploring treatment that may be available to you. Is the insurance company asking a lot more questions now because there is a return to LTD, and there may be an opinion that you cannot return to work for the foreseeable future? Very likely. It may also be happening that you're still in the own occupation phase of your policy. Remember, most policies have an own occupation and an any occupation phase. If you are approaching the any occupation phase, the insurance company definitely will be asking you more questions, will be exploring through assessments, internal assessments, or even independent medical examinations, whether you do have the transferable skills to work in another occupation that would pay to you something similar to your LTD benefit. So it is going to happen that the insurance company will be asking you more questions, and likely will be exploring that if you are approaching the change of definition. What can you do if your claim is denied? Contact us. We have an intake team that will review your situation and likely refer you to one of our lawyers to do an assessment with you and discuss with you what your options are. Remember, these consultations are done on a free basis. So when you contact us, we're not going to charge you for it, for that initial consultation. I'm hoping that was helpful. If you've got more questions, please reach out to us. And of course, as you can see on the screen, you can go to disabilityrights.ca for more information. Okay. Michelle B says, I am in the process of going off on disability leave, but just received note that they are closing down our branch. Does this change my claim? Do I still have coverage, or am I out of luck now? It's an interesting question. I think I would want to have more details on it, but I will say this. If you're in the process of going on disability leave, that would tell me, if I'm not incorrect on this, that you are seeing your doctor, and that your doctor and you have decided, or your doctor has recommended, that you're unable to work and that you should go on disability leave. If your employment is still in place, even if they're closing down the branch, if your employment is still in place, in other words, if you still have coverage under the terms of your employment, then you submit that claim as soon as possible. Because if your employment were to end, meaning that your coverage also ends, and you still have not submitted a claim, and then want to submit a claim afterwards, it is going to be a much more difficult thing to prove. Simply put, you have to prove that you are unable to perform the duties of your own occupation. In other words, that you have become totally disabled within the meaning of the policy, while you still have coverage under the policy. If your employer still continues to pay the premiums, or if you continue to pay the premiums, and your disability claim or your disability vested or recurred, in other words, you're using, prior to the termination of the coverage, then there is a claim to pursue, regardless of whether it is approved or denied by the insurance company. They may deny because of the merits, but the claim itself must have vested while the coverage was still in place. I'm hoping that answers your question. If they do deny you, please contact us and we can discuss with you what the options are. But I think I have the facts correct. You're in the process of going on disability. Your branch is closing down, but hasn't done so yet, so your coverage is still in place. Your coverage will end if your employment gets terminated, or if someone, for whatever reason, stops paying premiums. As you can see on the screen, go to disabilityrights.ca for more information. Michelle, if you do have questions, please reach out to us. Question on Facebook from Fina. If I'm receiving a pension or have unsecured debt, is this something an insurance company would look at as income? Pension, possibly. It depends on the wording of your policy. Each policy will have, we would call them offsets. Deductions is another word that we could use. Some are direct offsets, some are indirect offsets. Offsets mean things that the insurance company can deduct, other sources of income. For the vast majority of group policies, CPP disability benefits would be a direct offset. WCB benefits would be a direct offset. There may be others as well. It depends on what your policy provides for as an offset. So receiving a pension, if you have been receiving this pension from a previous employer, and you've been receiving it for a few years and now you're on LTD, that pension likely will not be an offset. But again, it all depends on the wording of the policy. Unsecured debt, I don't see that as a form of employment income or something that you contributed to, which is now being paid out because of your disability. So I don't see that as an offset or a deduction under the policy. But everything is said with the caveat that we would have to look at what the policy provides for. The policy is a contract. The contract governs the relationship between you and the insurance company and determines what the insurer can deduct and what they cannot deduct. So some cases will provide that CPP regular pension benefits may be an indirect offset. So again, depends on the wording of your policy. We're happy to review it with you if you've got more questions. Okay, Michelle B says, thank you, that's spot on. I will get my paperwork in as soon as possible. Make sure when you do that, Michelle, that your doctor details what your restrictions and limitations are. And make sure that you see your doctor regularly so that when the insurance company actually requests the records from your doctor, the visits that you have with your doctor will reflect why it is that you are unable to work and the discussions that were had why it is that you are unable to work. The fact that the branch is closing down cannot be the reason for disability. The disability has to be a medical illness that prevents you from performing the duties of your occupation. One thing to remember, when you deal with these cases, even with a workplace bullying and harassment situation, the assessment generally is, are you unable to perform the duties of your occupation? That word is key, not job, occupation. So the assessment will be, in your case, let's say it were to be a workplace bullying and harassment situation, they're going to assess, are you unable to perform your duties of your occupation? If you were to say, well, the branch is closing down, it was a very unpleasant place to work, I was being bullied and harassed, but of course I can go work somewhere else where I would be treated properly, and there wouldn't be bullying and harassment, your claim will be denied because it's not a disability, then it's a workplace issue. That happens so often, even in cases where it is a legitimate disability that may have resulted from workplace bullying and harassment. Insurers often still deny those cases. And in those cases, I urge everyone to contact us so we can review what the medical information is, because there are ways to deal with that. The doctors are key in those situations, because the opinion should be, if it is, that you must be unable to perform the duties of your occupation. Otherwise, it may just be a workplace issue. Okay, so I know there was another one here. Caro says, my mother has been off on disability leave for a few years now. She's thinking about taking her retirement early, but doesn't know how this will impact her LTD. Would it change her payments? Caro, very similar to the other question, also very important. Two things that I will say. Some policies will provide that if you are eligible for early retirement with a full pension, that your benefits will terminate entirely. Other policies will say, like I was saying with the other question, certain sources of income are deducted as offsets from your LTD benefit. So other than speculating on it, I would want to know what the policy provides for, because that is key. The policy is going to set out what can be deducted. So if early retirement pension is seen as an offset or is detailed as an offset under the policy, being it a direct offset, which means dollar by dollar, or an indirect offset, means a different calculation but still may impact the LTD benefit itself, that will all be detailed in the policy. So if your mother can get the policy, then we can have a look at it with her to see what is deducted and what is not deducted. Okay, where is the other question? June Sell says, I was recently cut off from my insurance because I refused to go to an appointment my insurer had made. It was 3 hours away and I have difficulty traveling due to my condition. It's absurd. How can they force me to do things that conflict with my condition and then punish me for refusing? That's a very good question, June. Under the terms of the policy, which is a contract, the insurer has the right to have you assessed by, let's say, a third party through an independent medical assessment. You're not the first person who has raised this, though, in the context that the request itself may not be unreasonable, but the request and the location with that specific doctor may be unreasonable. If you are required to travel very far, and that is counterintuitive, and it impacts your condition in a negative way. For example, let's say it is a chronic pain situation and you cannot travel for more than 30 minutes, but you're required to do this and it aggravates your condition, the argument surely can be made that that should not be happening. Some assessments are done virtually, some are done in person. So the argument should be that the insurance company has to look at what your personal circumstances are and what is reasonable. The fact that they've now denied your claim, they're doing it on the basis that you have breached, from their perspective, you have breached the terms of the policy, your obligations under the policy. In a situation like this, I strongly recommend that you reach out to an insurance lawyer to discuss how this happened, what evidence was in place. Did you have the written confirmation from your doctor that you could not attend this appointment? Did you say to them, I'm happy to attend an appointment, but not this one, because this one is 3 hours away. I cannot travel to it and it's going to worsen my condition. So it really depends on the fine nuances of what happened here, what evidence is in place. And even with the fact that they denied your claim, is it a legal claim to pursue? Possibly, but we would want to discuss with you what your circumstances are and the exact details as to what happened here. Please do not simply accept that they are correct. You're not, from the reading of your email, which is a good thing. Is there a way to fight this? Very likely, but we would want to have more information. I've got one more question that I can attend to, so let's quickly have a look. Question on Reddit from Aaron F. After being on STD, I applied for LTD and was denied claiming pre-existing condition. I appealed the decision and it took them 6 months to reject my appeal. They said I needed additional tests. That doesn't make sense. I've appealed again and I'm trying to get more information about what tests I need because they can be expensive. Should I continue to wait for them to respond? Is there someone I can get in contact with to get more information? No, you should not wait for them to respond. It's already been 6 months. A pre-existing condition is a denial based on the contractual reading of the policy, which means then that they've already made the decision that it is pre-existing because you were denied. The fact that you would need more tests doesn't really make sense to me, but of course I don't have all the information. The longer you wait, that limitation period continues to run. So I'm not suggesting that you contact us and sign up with us as a client. What I am suggesting you do is contact us so we can discuss with you what is happening here. We can review the information, look at the denial letter. Why is it that they are wanting you to go for further tests? Probably may make more sense once we have that information. And then once you've had that consultation, you can make a decision as to whether you want to wait further or you want to take other steps. It is important when you deal with these cases that you speak to somebody so you can make an informed decision. We deal with disability claims every day, not just disability, life insurance, critical illness, mortgage insurance, all those denials. And when we do that, we review the cases, we review the claim file, we review the denial letter, we review the policy. For somebody who is sick and who doesn't have the benefit of dealing with this on a regular basis, doesn't have the knowledge as to how to address and fight a denial, it is very important to make the inquiries, have a discussion with somebody who can give you the information. So again, and I've said this word so many times, you can make an informed decision as to how to approach it. With that, I have come to the end of the session. Thank you so much for the questions. I'll give you this information. The next session is an employment and disability law Q&A with my partner, Alex Lucifero. That is on August the 7th, which is this coming Thursday, 12:30 p.m. Eastern Standard Time. So I assume that would be 9:30 Pacific Standard Time. Thanks again, and tune to our next one, which would be my next one, would be August the 19th. I wish everybody a good week.